So welcome to the 2024 UNCITRAL Asia Pacific Days in Vietnam 2024, co-organized by Vietnam International Arbitration Center, the Vietnam Ministry for Foreign Affairs, and the United Nations, the UNCITRAL Secretariat, in the University of Law in Ho Chi Minh City. Today, in order to start our webinar today, I would like to invite Mr. Vũ Ảnh Dương, Permanent Vice President of VIAC and the Secretary General of VIAC, to give the commencement address.
Thanks, Ms. Hanks. Distinguished guests, esteemed colleagues, and honored guests. Good afternoon, ladies and gentlemen. It's my great honor to welcome you to the 2024 UNCITRAL Asia Pacific Days in Vietnam. The important occasion highlights our shared commitments to strengthen the foundation of international commerce and arbitrations, fostering deeper collaboration among countries, legal professionals, and academic across the regions. Today's event comes at a right timing as Vietnam is currently reviewing its law on commercial arbitration. This law, inspired by the principle of the UNCITRAL modern law and other key instruments, has provided a good foundation for the emergence and growth of the arbitration jurisdiction in Vietnam over 14 years. However, with the over 10 years of market dynamics and major changes in the landscape of Vietnam and the regions, there are clear needs to revise this legal framework. The goal is to further root and embed arbitration as a modern, civil, efficient, and justice mechanism for dispute resolutions, and thereby facilitating international trade and investment of Vietnam. This will also position Vietnam as a reliable and respected hub for dispute resolution in Asia-Pacific regions. This webinar marks the importance of academics collaboration. UNCITRAL works for harmonizing the international legal standards while respecting unique characteristics of national legal system, and VIAC remain deeply committed to humbly contributing to such discussion and advancing arbitration practice in Vietnam. Allow me to extend my sincere thanks to the co-organizers of this event, the Regional Center for Asia Pacific of UNCITRAL, the Ministries of Foreign Affairs of Vietnam, and the Ho Chi Minh City University of Law. Your dedication and partnership in creating platform for meaningful dialogues are invaluable. On behalf of Vietnam International Arbitration Center, I wish you an insightful and engaging times of discussions. So let's work together to contribute to shaping an arbitration landscape that is modern, equitable, and responsive to the complexity of international trade in Vietnam. Thank you for your participation and your continuous commitment to this important task. Thank you.
Yeah, thank you so much, Mr. Vũ Ảnh Dương. Now, we would like to invite Mr. Nguyen Thang, Director General, Department of International Law and Treaties, Ministry of Foreign Affairs, to give some further words to open this webinar.
Thank you, MC. Can you hear me?
We hear you very well, sir.
Thank you. Distinguished guests, esteemed colleagues and friends, on behalf of the Ministry of Foreign Affairs of Vietnam, it is our great pleasure to join the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, and the Vietnam International Arbitration Center and the Ho Chi Minh University of Law in organizing the 2024 UNCITRAL Asia Pacific Day in Vietnam, so-called 2024 AP Day. This year's event is a fitting occasion to showcase Vietnam's commitment and contribution to the work of UNCITRAL. We believe that UNCITRAL work is essential in harmonizing and modernizing the rules that underpin international trade. As a member of UNCITRAL during the 2019-2025 term, we have actively participated in various activities of UNCITRAL, particularly in the areas of dispute resolution and investor arbitration reform. Through our involvement in Working Group 2 on dispute settlement and Working Group 3 on ISDS reform, Vietnam has sought to ensure that discussion reflect the perspectives and needs of developing economies and the practice of different legal systems, including that of Vietnam. In this context, I'm particularly proud to highlight Vietnam's recent re-election as a member of UNCITRAL for the second consecutive term, 2025 and 2031. We reaffirm our dedication to promoting the objectives of this esteemed body. It is through events like the Asia Pacific Day series that we can deepen our understanding of UNCITRAL's takes on international trade law, promoting their dissemination, share best practices, exchange ideas, and collaboratively address the challenges and opportunities in this field. As always, Vietnam has been and will continue to be committed to promoting such dialogues, both at regional and global levels. We are looking forward to the continuing collaboration with the UNCITRAL Secretariat, the Vietnam International Arbitration Center, and other interested partners in this endeavor. This year, AP Day is also timely when Vietnam is reviewing its law on commercial arbitration, which I believe will certainly take into account UNCITRAL standards in this field. In closing, I would like to express my gratitude to the other co-organizers for their tireless efforts in making this event happen. Thank you, and I wish you all a very successful event.
Thank you so much, Mr. Nguyen Đăng Thang. Now, I would like to invite Associate Professor Trần Dzung, Vice Rector of the Ho Chi Minh City University of Law, one among the top, largest and biggest and most prestigious tertiary education of law in Vietnam, to give opening remark for this event.
Can you hear me? Hello?
We can hear you well.
Okay.
Thank you.
A very good afternoon from Ho Chi Minh City. Distinguished ladies and gentlemen, it is a great honor to welcome you to this important online workshops titled Introduction to UNCITRAL Model Law on the International Commercial Arbitration, Overview of UNCITRAL Work on ISDS. Although we are gathering virtually today, the relevance of importance of this workshop could not be more profound as we continue to navigate a global economy that is becoming increasingly interconnected and rapidly evolving in the frameworks that guide the resolution of international commercial disputes, specifically in the UNCITRAL model law on the international commercial arbitration and the investment disputes settlement mechanism. We are more happy to offer the unique opportunity to delve deeply into these frameworks and explore how they shape the future of international trade, investment, and dispute resolutions. We are incredibly fortunate and to have an outstanding lineup of experts joining us, both from the internationals and the Vietnamese legal communities. We are honored to welcome Ms. Athita Komindr and Mr. Jae Sung Lee from the UNCITRAL Regional Center for Asia and the Pacific. Their valuable insight into the history, structure, and global impacts of the UNCITRAL model law and the ISDS mechanism will undoubtedly help us to better understand the international standards and that govern the arbitration practice and dispute resolution system around the world. Equally important, we also welcome the Vietnamese leading practitioners and scholars in the field of arbitration and Mr. Nguyen Dzung and Ms. Dr. Nguyễn Thị Hoa, who will share their perspective on Vietnam engagement with these international frameworks and how we are adapting them into the Vietnam context. Additionally, we are having honor to have Ms. Lại Thị Vân Anh from the Ministry of Justice, who will provide insight on Vietnam approach on the investor-state dispute settlement, addressing key challenges and opportunities in this area. This workshop is much more than just academic learning experience. It is an valuable platform for dialogue where we can explore the challenges, exchange solutions, and also to build a stronger connection that will help to shape the future arbitration and dispute resolution in Vietnam and the broader Asia Pacific region. Whether you are a legal practitioners or business leader or government representative or scholar or anyone with the interest in this area, this workshop present a fascinating opportunity for all of us to engage with cutting-edge legal concept and practices. This insight will undoubtedly influence the way we approach the dispute resolution in the year to come. As we stand at the crossroad of rapidly changing legal and commercial landscape, the knowledge we can today will equip us to navigate shape these transformations. I strongly encourage each of you to actively participate, ask questions, and share your perspective as embark on this insightful journey together. While the format may be virtual, I strongly believe that the opportunity for meaningful connection, learning, and collaboration is very real. And once again, I would like to extend my sincere thanks to all of you for being here and for your participation in this significant event. I'm confident that these discussions today will be enriching and will contribute to strengthening the legal and arbitration framework in Vietnam and across the Asia Pacific regions. And on this note, I would like to wish all productive and stimulating workshop. Thank you very much.
Thank you so much. Now, before we go to the main part of this webinar today, we would like to inform you that for this webinar, we have received 320 registrants. And for now, we are having over 150 participation with us now with the speakers and the organizers. So without further ado, I'd like to invite you to go to the section 1, overview of the legal framework and arbitration of the United Nations Commission on International Trade Law, UNCITRAL. The keynote speaker of this session 1 is Ms. Athita Komindr, head of the UNCITRAL Regional Center for the Asia and the Pacific. And also, Ms. Athita Komindr will have the co-speakers, Mr. Jae Sung Lee from UNCITRAL RCAP. And now the floor is yours, Ms. Athita Komindr and Ms. Lee, please.
Thank you very much for the kind introduction. I hope everyone can see my screen well and also hear me well. And also to note that I'm head of the UNCITRAL Regional Center for Asia and Pacific. My colleague, Dr. Jae Sung Lee, is Senior Legal Officer from UNCITRAL in Vienna, where we have our headquarters. So he will be joining the panel discussions later to give his insights about the model law. And then also to give updates about ISDS reform, because Dr. Lee, Jay, is also the secretary to UNCITRAL Working Group 3. So for now, I understand my task is to deliver an overview, a keynote of introducing UNCITRAL and focusing on the UNCITRAL model law and international commercial arbitration, which will be the focal point of the panel discussions after this. So with that short informal introduction, let me launch into my presentation. So Vice Rector and Associate Professor Tran Dzung of Ho Chi Minh City University of Law, Director Nguyen Thang of Vietnam's Ministry of Foreign Affairs, Mr. Vu An Duong, Permanent Vice President, Secretary General of the VIAC, Vietnam International Arbitration Center, dear esteemed speakers, including from Vietnam's Ministry of Justice, participants, and especially HCMC ULAW students. Greetings from the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific in Incheon, Republic of Korea. I'm delighted to deliver this address at Vietnam's 2024 UNCITRAL Asia Pacific Days, with special thanks to HCMC ULAW and the organizing team at VIAC. Vietnam's AP Days activity forms part of the global UNCITRAL Days activities, comprising academic gatherings organized with universities and institutions of higher learning across the world, from Africa, the Arab states, and Latin America, and the Caribbean, in addition to the Asia-Pacific region. And these activities seek to raise awareness of UNCITRAL instruments and the importance of legal harmonization among students and bright young minds who are the next generation of legal thinkers and potential policymakers. In this context, the Secretariat is so honored to also receive support from our friends at the Ministry of Foreign Affairs of Vietnam and warmly welcomes the opportunity to engage with senior officials and legal experts in this academic forum, elevating the AP Days activity to include practical dimensions of possible legal reforms as well. So allow me to first briefly introduce UNCITRAL for students and participants who might be newer to our work. Based in Vienna, Austria, the United Nations Commission on International Trade Law promotes the harmonization and modernization of international commercial law to facilitate trade and advance sustainable development. When world trade began to expand dramatically in the 1960s, states began to realize the need for a global set of standards and rules to harmonize and modernize the assortment of national and regional regulations, which until then largely governed international trade. They turned to the United Nations, thus leading to the General Assembly establishing UNCITRAL in 1966, which has since then become the core legal body of the United Nations system in the field of international trade law. UNCITRAL rules are negotiated and endorsed by member states, representing different legal traditions and levels of economic development. If it's just one country's system, it won't work. The mandate of UNCITRAL thus highlights the promotion of the progressive harmonization and unification of the law of international trade, and was designed to address concerns that conflicts and divergences arising from the laws of different states in matters relating to international trade constitute an obstacle to the development of world trade. To promote and achieve legal harmonization, UNCITRAL issues legal instruments endorsed by states, which they use to support their commercial legal environment. These legal texts take different forms, such as conventions, model laws, and legislative guides, and cover the life cycle of businesses for commercial transactions, ranging from business registration, including simplified incorporation for small businesses, to e-commerce and digital sales and uniform sales law, access to credit and financing, dispute settlement, of course, insolvency, and other areas. All UNCITRAL texts are published on the website in the 6 official languages of the United Nations: Arabic, Chinese, English, French, Russian, and Spanish. My office, UNCITRAL RCAP, the Regional Center for Asia and the Pacific, is UNCITRAL's only regional center. There's only one, and has been operating since 2012 in Incheon, Korea, with the generous support of the Korean government and also Hong Kong, China. RCAP works to give meaningful effect in the Asia-Pacific region to UNCITRAL's global mandate of furthering the progressive modernization and harmonization of international trade law. And since RCAP's establishment in 2012, most of the 60 Asia-Pacific jurisdictions that RCAP services have adopted at least one UNCITRAL text, greatly contributing to legal harmonization. Turning to the UNCITRAL arbitration framework, UNCITRAL has worked throughout the years to create a favorable environment for resolving disputes arising from cross-border transactions, with the aim of developing a fair and efficient resolution system. This work contributes meaningfully to the achievement of Sustainable Development Goal 16, which is the promotion of access to justice and governance in accordance with the rule of law, and furthers the development of a mature, rule-based global commercial system. In addition to international commercial arbitration, dispute settlement topics covered by UNCITRAL include international commercial mediation, online dispute resolution, and most recently, dispute resolution in the digital economy. The New York Convention, to which Vietnam is party, is perhaps the most well-known amongst UNCITRAL arbitration instruments. With near universal participation by 172 states, with Suriname and Timor-Leste being the most recent, the convention is foundational to the global arbitration community, as it provides common legislative standards for the recognition of arbitration agreements and court recognition and enforcement of foreign and non-domestic arbitral awards, which can be challenged only under very limited circumstances, and thus facilitates the resolution of disputes through arbitration in all corners. The convention is an excellent example of global legal harmonization. The practices highlighted in the UNCITRAL Secretariat Guide on the convention demonstrates that despite the diversity of the contracting states' legal systems, the interpretation and application of the convention has been rather consistent and in conformity with the convention's policy of favoring recognition and enforcement. In accordance with obligations taken on under the convention, many contracting states that first adhered to a more interventionist approach to international arbitration have since moved towards a liberal regime that limits court control over the arbitral process. The New York Convention, however, does not deal with either the substantive or the procedural law of arbitration, areas which are left largely for national legislators. This is where the UNCITRAL Model Law on International Commercial Arbitration comes into play. Adopted in 1985 with amendments in 2006, the model law is a set of rules designed to assist states in reforming and modernizing their laws on arbitral procedure so as to take into account the particular features and needs of international commercial arbitration, covering all stages of the arbitral process. It reflects worldwide consensus on key aspects of international arbitration practice, having been accepted by states of all regions and the different legal or economic systems of the world, and serves the purpose of establishing a unified legal framework for the fair and efficient settlement of disputes arising in international commercial relations. As opposed to a convention, which is an instrument that is binding under international law on states and entities with treaty-making capacity that choose to become a party to that instrument. A model law is created as a suggested pattern for lawmakers in national governments to consider adopting as part of their domestic legislation. The model law has gained considerable success, as you can see. Currently, there are 93 states, totaling 126 jurisdictions that have adopted the model law, with over 30 jurisdictions in the Asia Pacific, listed on your screen for ease of reference. The model law consists of 8 separate chapters and is based on key principles, which are party autonomy, the limited intervention of courts in the arbitral proceedings, the competence of the tribunal to determine its own competence, the separability of the arbitration agreement from the contract in which it is contained, and the setting aside as a sole recourse against an arbitral award. We will see how these principles are reflected in the model law. Due to time considerations, I will focus on the model law's scope of application, court assistance and supervision, the arbitration agreement, jurisdiction of the arbitral tribunal, recourse against an award, and recognition and enforcement. Regarding its scope of application, the model law applies to international commercial arbitration, the terms of which are broadly defined in the text. In sum, the model law characterizes an arbitration as international if the parties to an arbitration agreement have, at the time of the conclusion of that agreement, their places of business in different states. The term commercial is to be widely interpreted and includes matters arising out of relationships that might be described as commercial in nature, whether contractual or not, while the term arbitration covers any arbitration, whether or not administered by a permanent arbitral institution. In addition, the model law envisages and limits specific instances where national courts can intervene. For example, on issues of appointment of an arbitrator, jurisdiction of the arbitral tribunal, recognition of the arbitration agreement, setting aside of the arbitral award, and recognition and enforcement of interim measures. Chapter 2 of the model law deals with the arbitration agreement, including its recognition by courts. As you can see in the blue box, the arbitration agreement is defined as an agreement by the parties to submit to arbitration all or certain disputes that have arisen or may arise between them in respect of a defined legal relationship, whether contractual or not. The original 1985 version of the provision closely followed Article 2.2 of the New York Convention, requiring that an arbitration agreement be in writing. However, practitioners subsequently pointed out that in a number of situations, the drafting of a written document was impossible or impractical, and thus where the willingness of the parties to arbitrate was not in question, the validity of the arbitration agreement should be recognized. In amending Article 7, the Commission adopted 2 options. The first option follows the New York Convention in requiring the written form of the arbitration agreement, but recognizes a record of the contents of the agreement in any form, including orally, as equivalent to traditional writing, as long as the content of the agreement is recorded. Reference is also made to the use of electronic communications, inspired by wording from the 1996 UNCITRAL Model Law on Electronic Commerce and the 2005 United Nations Convention on the Use of Electronic Communications in International Contracts. The second approach defines the arbitration agreement in a manner that omits any form requirement. No preference was expressed by the Commission in favor of either option 1 or 2, both of which are offered for enacting states to consider, depending on their particular needs, and by reference to the legal context in which the model law is enacted, including the general contract law of the enacting state. Both options are intended to preserve the enforceability of arbitration agreements under the New York Convention and establish a more favorable regime for the recognition and enforcement of arbitral awards than that provided. Next, the model law addresses the complex relationship between the arbitration agreement and the resort to courts. Article 8 is modeled on Article 2.3 of the New York Convention and obliges any court to refer the parties to arbitration if the court is seized with a claim on the same subject matter, unless it finds that the arbitration agreement is null and void, inoperative, or incapable of being performed. This provision, where adopted by a state enacting the model law, is by its nature binding only on the courts of that state. However, since Article 8 is not limited in scope to agreements providing for arbitration to take place in the enacting state, it promotes the universal recognition and effect of international commercial arbitration agreements, thus enhancing harmonization of international commercial law. Article 9 of the model law expresses that any Article 9 of the model law expresses that any interim measures of protection that may be obtained from courts under their procedural law are compatible with an arbitration agreement. Chapter 4 of the model law addresses a tribunal's competence to decide its jurisdiction and power to order interim measures. With regard to jurisdiction, Article 16 of the model law adopts the principle of competence, allowing the arbitral tribunal to rule on its own jurisdiction independently, including any objections with respect to the existence or validity of the arbitration agreement, without having to resort to a court. Article 16 also adopts the principle of separability, meaning that an arbitration clause shall be treated as a separate agreement independent of the other terms of the contract. Consequently, a decision by the arbitral tribunal that the contract is null and void does not invalidate the arbitration clause. The article also provides that any objections to jurisdiction should be made at the earliest possible time. The competence of the arbitral tribunal to rule on its own jurisdiction is not unlimited and thus subject to court control. In particular, where the arbitral tribunal rules as a preliminary question that it has jurisdiction, the law allows for immediate court control to avoid wasting time and money, with procedural safeguards built in to prevent or reduce the effect of diversionary tactics, such as a short time period for resort to court, 30 days, court decision not appealable, and discretion of the arbitral tribunal to continue the proceedings and make an award while the matter is pending before the court. Next, the model law covers a tribunal's power to order interim measures and preliminary orders, addressing different issues such as definition of interim measures and the conditions for granting such measures, the application for and conditions for the granting of preliminary orders, rules applicable to both preliminary orders and interim measures, and court-ordered interim measures, entrusting courts with the same power of issuing an interim measure concerning arbitration proceedings. These sections were adopted and included in the model law by the Commission in 2006, replacing Article 17 of the 1985 version of the model law. A notable innovation of the revision lies in the establishment in Section 4 of a regime for the recognition and enforcement of interim measures, which was modeled on the regime for the recognition and enforcement of arbitral awards under Articles 35 and 36 of the model law. Chapter 7 of the model law deals with setting aside the arbitral award. The disparity found in national laws as regards the types of recourse against an arbitral award available to the parties presents a major difficulty in harmonizing international arbitration legislation. As such, the model law provides only one type of recourse: application for setting aside may only be made to a court in the state where the award was rendered. The model law also provides an exhaustive list of the grounds on which an award may be set aside, which essentially mirrors that contained in Article 5 of the New York Convention, namely grounds which are to be proven by one party, which are the arbitration agreement is invalid or parties lack the capacity to conclude it, the party was unable to present its case or was not properly notified, The award deals with matters outside of an arbitration submission scope. And the conduct of proceedings or composition of the tribunal was contrary to parties' agreement or failing such agreement to the model law. The model law also contains the grounds that a court may consider of its own initiative, which are whether the subject matter of a dispute is non-arbitrable or whether the award violates public policy. The last chapter of the model law deals with recognition and enforcement of awards. The underlying premise is uniform treatment of all awards, irrespective of country of origin. By treating awards rendered in international commercial arbitration in a uniform manner, irrespective of where they were made, the model law distinguishes between international and non-international awards based on substantive grounds rather than territorial borders, which are inappropriate in view of the limited importance of the place of arbitration in international cases. Moreover, based on these considerations and the desire of overcoming territorial restrictions, reciprocity is not included as a condition for recognition and enforcement. As per the blue box on your screen, an arbitral award shall be recognized as binding and enforced subject to the provisions stipulated in the model law, which parallel the relevant recognition and enforcement provisions of the New York Convention discussed in the previous slide on setting aside the award, with one difference. The model law specifies the annulment itself as a valid ground for the refusal of the award's recognition and enforcement. So that concludes my overview of the model law, which will be discussed in more practical detail in the following panel session. But my overview also includes other aspects of UNCITRAL'S work. So I will now move to that part. So widespread enactments of UNCITRAL model laws and other legal instruments help advance legal harmonization. But in practice, harmonization also requires that the laws concerned are interpreted and applied in a uniform manner. So as lawyers, we know this well. And many UNCITRAL texts, including the model law on international commercial arbitration, reflect that understanding by providing that in the interpretation of the text, regard is to be had to its international origin and to the need to promote uniformity in its application. To this end, UNCITRAL established the case law on UNCITRAL text database, or CLOUT, C-L-O-U-T, in 1988 to collect and disseminate information on judgments and arbitral awards related to UNCITRAL texts. Abstracts of case law included in CLOUT are freely accessible on the UNCITRAL website in the 6 official United Nations languages, together with the respective judgments and awards in their original language. And the CLOUT database is searchable by jurisdiction and by UNCITRAL instrument. For instance, if you go to the CLOUT database and select Republic of Korea, summary information about CLOUT cases from Korea will appear on the left side, including the total number of published cases, broken down into court decisions and arbitral awards, and the UNCITRAL instruments addressed, such as the CISG, the New York Convention, and various model laws. CLOUT is updated regularly with new case law. If you're interested in receiving updates on recent CLOUT cases, please subscribe to its tri-annual newsletter, which can also be accessed from the shown UNCITRAL website. In addition, UNCITRAL is always interested in receiving voluntary contributions of abstracts of new cases or arbitral awards discussing UNCITRAL texts, especially from underrepresented jurisdictions in the CLOUT database, such as Vietnam, for possible inclusion. And the names of the voluntary contributors whose abstracts are included would also be published for those of you interested in submitting a voluntary submission to CLOUT. For those interested in learning more about UNCITRAL, I invite you to visit the UNCITRAL website and take our free online training courses. These currently include Introduction to UNCITRAL, including how UNCITRAL's work contributes to sustainable development, UNCITRAL text on public procurement and public-private partnerships, UNCITRAL insolvency text, the UNCITRAL mediation framework, and also the UNCITRAL Arbitration Framework. And these online training courses are free, currently available in both Chinese and English, with other UN languages forthcoming. So for students here interested in learning more about the work of UNCITRAL, internship positions are now open for application at RCAP with an application deadline of 1 January 2025. And they're also open for internship positions at UNCITRAL in Vienna. The application deadline is a couple days earlier than that of RCAP. So by the, I think, 28th of December, but you can check the details on the UN Careers website. So the internship positions are for a minimum of 2 months and a maximum of 6 months with various starting dates. For this period, the starting date would be from 1 April until 30 September 2025. And the objective of the internship is to provide training to the interns on the work of UNCITRAL. And the interns also assist RCAP staff with a wide range of projects. And examples include analysis of the laws of various Asia-Pacific jurisdictions, particularly in comparison with UNCITRAL legal instruments. For example, examining whether a jurisdiction has adopted a model law in conjunction with the oversight of our Vienna-based colleagues. Regional research of case law on UNCITRAL texts and trade law developments, for example, helping to identify potential CLOUT cases of interest that aren't yet published. Assisting with preparing presentations to help raise awareness of legal harmonization and the work of UNCITRAL, and assisting in capacity building activities like the present Asia Pacific Days event. To be eligible to apply for the internship, you can see the qualifications there. So applicants must be enrolled in or have completed either a graduate school program or the final academic year of a first university degree program. Applicants should be familiar with standard computer and word processing applications. They should be interested in the work of UNCITRAL and be able to work with individuals of different cultural backgrounds and beliefs. No working experience is required to apply for the internship program. And applicants should be fluent in oral and written English, and knowledge of another UN official language or regional languages in the case of RCAP would be an advantage. Finally, we're currently soliciting input from students. The commission would like to hear from students. So I'd like to give some time now to ask student participants here to share their thoughts on how UNCITRAL could more effectively engage with younger audiences. So please scan the QR code that appears on your screen and fill out your ideas. Your answers are completely anonymous. We just like your feedback, and your input will help us explore new ways to connect with and inspire the next generation. So please scan the QR code there on your screen. You can share it with your friends who are also students. We'd love to hear from you. All right, and this is a different QR code. So this ends my overview of the UNCITRAL Arbitration Framework and Learning Resources. Thank you again to HCMC ULAW, VIAC, and MOFA for supporting the work of UNCITRAL and for joining the UNCITRAL Asia Pacific Day celebrations. UNCITRAL RCAP looks forward to continuing our fruitful collaboration with Vietnam. And this QR code is to subscribe to the RCAP newsletter in case you're interested. Thank you very much for your attention and for this privilege. Thank you.
Thank you so much.
Thank you for the reactions.
Thank you so much, Ms. Athita Komindr, for your very informative presentation. I see so many comments and questions maybe for your presentation. So as I understand that Mr. Lee will join from Vienna, right? So I'd like to invite Mr. Lee to start with your presentation, sir.
I actually don't have anything to add. I'll actually pass it over to the moderator of session 2 to start the session 2.
Okay. Now we would like to invite the audience to the session 2 of the webinar, the Vietnam's Considerations on the Uncintral Model Laws on International Commercial Arbitration. The moderator of this session is Mr. Nguyen Dzung, Director at ADR Vietnam Chambers, the Deputy Director of the Vietnam Institute for International Arbitration Research and Training, a division of VIAC. Now I'd like to invite Mr. Dzung to moderate the session.
Thank Hằng for your introduction. My name is Minh Dzung. I am the founding chairman of Dzung Associates, one of the leading arbitration law firm in Vietnam with more than 30 years of experience. And now I become an independent arbitrator at ADI Vietnam Chamber. But this afternoon, I will moderate the second session in the capacity of the Deputy Director at the Vietnam Institute for International Arbitration Research and Training. Short name is VIART, a division of the VIAC. It's my great pleasure to sit together with our distinguished speaker today. The first one, I would like to introduce Dr. Jae Sung Lee. Dr. Lee is a senior legal officer at the International Trade Law Division, United Nations Office of Legal Affairs, based in Viet. He is functioning as involved as secretary of the Working Group 3 on SDS reform, and has served as secretary of Working Group on Dispute Settlement, Security Transaction, and Electronic Commerce. Dr. Lee obtained his PhD at the School of Law of Seoul National University. The second speaker is Dr. Nguyễn Thị Hoa, the law lecturer at the University of Law, member of the Standing Committee of the Vietnam Society of Construction Law, SCL Vietnam. Dr. Hoa has been a lecturer of the Law Faculty of the University of Law since 2019. She's obtained her PhD specialized in arbitration, construction arbitration. So it's my great pleasure to moderate a discussion with Dr. Lee and Dr. Hoa. Before our speaker will present his view on the second session, Vietnam Consideration on the Uncintral Model Law on International Commercial Arbitration, I observed that there's quite a lot of comment on the keynote speech by Athita Komindr. And I note that there are three important questions that many comments suggest that Vietnam should fully adopt the modern law into its legal arbitration framework. Are there any reason for this beyond the fact that the modern law is advanced? The second question is, why don't we just adopt entire the modern law? Is there any problem if we adopt entire modern law for the NCA in Vietnam? More insight, please. Or the question is, take Cambodia as an example. It recognized as a modern law country, but does anyone consider its arbitration legal framework to be advanced for leading arbitration hub? I think that's very interesting question. I hope that Dr. Lee and then Dr. Hoa may cover that question in their presentation. Now I would like to invite Dr. Lee to go first. Dr. Lee, please, floor is yours.
Thank you. Thank you for the introduction. My name is Jae Sung Lee, and as introduced, I have been working in the field of dispute resolution in UNCITRAL for some time. I think I've been following the chat and the questions with interest, and I think that's actually a good starting point for our discussions because Vietnam is trying to revise or amend its arbitration law, but you have to ask why. And that is the first question, because there has to be a shared understanding in the country of why there is the need for reform. Because I think some of the people actually said in the chat, there are countries that do not have not adopted the model law, but have a very nice dispute resolution framework. Their arbitration is working fine. So I think before we get into the discussions, you may want to consider why you need to reform your Vietnam law. The model law on secure transactions or the arbitration law is supposed to be a default rule. In arbitration, party autonomy is more important, and parties are able to agree on arbitration rules which would govern the proceedings. And when they have not agreed on those kind of rules, the model law or the arbitration law functions as the default rules. So if you have a very sophisticated institutions, like for example, VIAC is the one, and they have a good administrations, you may not need to have the model law. But I don't think that is really the case in Vietnam. And I think to build the arbitration framework in Vietnam is why you need to consider revising your model, your arbitration law based on the model law. And I think I also saw a comment in the chat that the law is not everything. Cambodia is a model law country, but their arbitration framework or the arbitration is not operating as fully as it should be. So this is one additional thing that to consider. I was going through some of the documents, and you may wish to recall that the World Bank had a doing business report, which has now been changed to the Be Ready report, where they've assessed the dispute resolution environment in Vietnam. You're ranked quite high in that ranking, along with Indonesia and the Philippines. But what I see is that the regulatory framework is quite ranked high, and the operational efficiency is high. But the public services related to arbitration has been ranked low, which is why Vietnam is ranked in the second quantile. So I think this is kind of, you need to look at the bigger ADR environment, whether there is an enough pool of arbitrators, whether the law is there, whether there's an institution that's functioning, and of course the support that you get from a court. So I'll not go into the details of the model law or the provisions of the Vietnam arbitrations law, but there are other issues that you may wish to consider in considering the reforms. First, there have been developments in the region. I mean, for example, Cambodia adopted the model law that was mentioned. Singapore, Malaysia are all doing reforms. So there's a lot of developments in the field of arbitrations and arbitration institutions with providing additional and very efficient services. Second, other dispute resolution methods other than arbitrations have also been developed. You have mediations, and you have courts that are also operating quite efficiently. So arbitration is competing with different resolution methods. Third, arbitration is not also considered efficient anymore. Sometimes it's considered as a very long process and a very costly process. So in order to ensure that arbitration finds its really efficient modes of dispute resolutions, you have to ensure that. So, and I think Athita mentioned this, but in order to capture all of this, whether you're in a model law country or not is not really relevant. You have to actually look at how many cases are being handled by VIAC, how many cases are being set aside by the courts, how many arbitral awards are being enforced by the courts. And all of these needs to be captured and they have to be reported so that people understand what the arbitration environment in Vietnam is like. And I think this may be lacking in Vietnam. So this is something to be considered. Lastly, what we've seen is that arbitration reforms is sometimes you need a coordinated effort. You can't be only an arbitration institutions that wishes to go forward. And I'm happy to see MOFA here, but you need to also involve all of the different ministries that are involved in arbitration to ensure that you have a coordinated approach and to deliver the reforms that you need to. And here I would also call on for you to involve the courts because their support or interventions in the arbitration process is something that needs to be considered and their views need to be considered because even if you do everything right and if the courts do not support, it's not going to be a reform that you wish to achieve. And of course, I see that the Vietnam Lawyers Association has been given the lead to amend those laws, but it's also very important to have a lead authority where the different views are considered so that the reforms can be moved forward. And I think that is a very important point that we have earned from all of the different reforms that we've been able to undertake. And as Athita mentioned, the model law is only a model. It is not the perfect solutions for everybody. And there is room for flexibility for states to take into considerations their own needs. So it is definitely somebody mentioned that why don't we copy paste the model law entirely? That's also done. We've seen states do that. But you have to also know that the model law has some blanks. It is supposed to be for the state to fill in the blanks, but we've also seen states actually copy and paste the model law with the blanks and not fill in the blanks, which is a big problem. I know that we've gone a little bit past, but I just wanted to go to I was shared the document from the chair of the editorial board on the second session of the drafting of the amendments to the model law, amendments to the Vietnam law, which was prepared, I believe, by the Vietnam Lawyers Associations as the lead authority for the amendment process. And I just wanted to mention the 4 policies that has been mentioned there because I fully agree with those policies. First, one of the policies is to clearly regulate and expand the scope of disputes resolved by commercial arbitrations. And I think Athita touched upon this, but the arbitrability or the meaning of commercial needs to be cleared so that the amount or the number of disputes that can be arbitrated could be expanded. That I fully agree. Second, you have to enhance the commercial arbitration process, and this can be done by different arbitration rules as well. As I mentioned, the model law is a default rule when the parties have not been able to agree on those rules. So if the VIAC actually has a very sophisticated rules that parties can adopt to, parties have that choice. If they have not done so, the model law or the Vietnam law comes into the picture, and that is why the model law is important. Policy 3 was to expand the jurisdiction powers of the tribunal in the arbitral process, and we fully agree. In this, I actually go back to the part about the efficiency of the arbitration process, because you need to give the discretions to the tribunal to manage the disputes in a way in order to ensure that the dispute could be resolved in an effective manner. And that is why broadening the discretions and clarifying the jurisdictional powers of the tribunal is very important from our perspective. And policy 4, adjust regulations regarding arbitral awards, annulment of awards, and the review of the court's decisions on setting aside arbitral awards. And here is where I actually would recall my mention that you need to involve the courts. This falls within the court's authority to set aside awards, to refuse enforcement, and to support enforcement. So under the model law, as Athita has mentioned, judicial support is a key element in the model law. They need to support the arbitration process for them to function properly, but they should be intervening in a limited fashion. That is what the balance is in the model law. And you need to ensure that the courts understand their role in the arbitration process. It's not as if they're taking away the dispute resolutions of the court authorities, but they have to be supportive and know exactly when to intervene and when not to intervene. And I just wanted to also mention that the principle of party autonomy is key in the model law, and this needs to be considered in the overall policies. So I think that's all I have to say for now. I know that Athita mentioned this, but UNCITRAL Secretariat stands ready to support any of the reforms. We review amendments processes. If you send us comments on an amendment bill, we are happy to give you comments. I know that we have actually did a comment on the 2010 law, but I know that's probably outdated now because you'll probably come up with a new draft. And the Secretariat is ready to support that. If you need to go to the parliament, you need to explain to the national legislators, we're happy to also extend support for a bill which is based on the model law. And I'm happy to answer any questions that the presenters may have. And I see that there's a very interesting discussions going on chat, and I'm happy to follow that as well. Thank you.
Thank you, Dr. Lee, for your presentation. It's very comprehensive. I have a quick comment on your presentation. I think Vietnam is strictly observe on the recent development of the arbitration legislation in the region. We note the situation of China, India, and some other jurisdictions such as UK. We also share your same view that arbitration not only is a method to settle the dispute, we also have another alternative dispute resolution such as mediation. And we are thinking now about the similar law on the commercial mediation based on anti-trust principle, but this is not the topic today. I also share the same view with you about the user demand for the efficiency. I understand that there's so many complaints about the costly or wasting time arbitration process in surround the region. However, for Vietnam, I don't think that is a problem for Vietnam at the moment, because for VIAC example, the average time for the VIAC to handle an arbitration case about 6 months only. And the arbitration cost is, I'm sure that is the total cost is not more expensive than litigating in the court system. The thing I also plead to share to you and the anti-trust colleagues that recently ICCA International Council of Commercial Arbitration held a training course for all judges of the Supreme People Court in Phú Quốc and in Nguyen. And we also deliver to the court system the ICCA guidebook on the New York Convention. So many support from the international donor. And the last thing I have to say is that Vietnamese court, Supreme People Court really supports the arbitration in Vietnam. I can share with you that also we draft and issue the law on commercial arbitration in 2010. However, until 2014, the Supreme People Court issues the resolution 01, and that time is the time the arbitration actually developed in Vietnam with the court support. Without the court support, the tribunal will not have the power to issue the interim measure as the law provided now. So no doubt about the court system support here, and I'm very pleased to hear that UNCITRAL also support Vietnam Lawyer Association drafting committee for key policy. I can say with you that when we draft the law on commercial arbitration 2010, where I was editing member of the drafting committee, Vietnam is not member of the UNCITRAL. But now Vietnam is a member of the UNCITRAL, as I understand that Dr. Lai Vân Anh of Ministry of Justice is there. I'm sure that we will work closely with UNCITRAL and hope that it will support our legal making. All right. So now we would like to invite Dr. Nguyễn Thị Hoa for her presentation. Dr. Hoa, the floor is yours. Thank you.
Thank you so much for the presentation of the Professor Dr. Dzung, and regarding the discussion that I have heard via the chat, and also by listening the presentation of Dr. Lee. I understand that why we have the discussion today, the most important thing is that we want to find a solution to facilitate Vietnamese arbitration. And it's true that I believe that everyone today, when we join this event, we want to find a way to, so that first of all, Vietnamese arbitration can develop, and the second one is that Vietnam can become a place of arbitration at international level. And so this is the reason why the question is whether or not if we follow the model law, this would be a good way so that Vietnam can become a top arbitration at international level or not. However, when regarding, for example, I understand when I study a lot of research of other experts regarding following the model law, there are different explanations that yes, when we follow the model law, it would be a good reason so that the Vietnamese state can attract foreign investor to develop international commercial activity, because as we all know that arbitration is a product in service of international commercial activities. Therefore, if we follow the model law, that a lot of international experts understand the concept and also the concept of arbitration. I think the practitioner will become, how to say, familiar to also to Vietnamese arbitration law. This might be advantageous for Vietnam when we follow the model law in the future. So the question now is how Vietnam can follow the model law. For example, if we have to follow 100% or we will adopt entire model law, like the case of the Singapore, or we should adopt, how to say, 70% or 80% of Vietnamese law. Vietnamese law is similar to model law is enough to be considered as a model law country, for example. For example, I have studied the research of Professor Đỗ Văn Đại, who is also a world expert in Vietnam. And for him, currently Vietnamese law has a lot of common point regarding the model law. And also for the professor, for Dr. Xuân Hợp, he has also has a conclusion that Vietnamese arbitration law currently has a lot of common point compared with the model law. And then I studied also the suggestion of UNCITRAL when the Vietnamese law adopted, and then the UNCITRAL also has some suggestion. For example, and regarding those suggestion, I understand that there are a lot of provision that Vietnam are not difficult to follow. For example, regarding the Article 30, the loss of right to, in this case, I understand that the model law proposed at the proposal that we can add the in more detail, what does it mean the time limit for the party to object the violation during the arbitral procedure? I think we can follow this or other provision regarding the arbitration agreement at Article 7 of the model law. Regarding Vietnamese law, consider currently, for example, now Vietnam really open for the party to bring their dispute to arbitration, whether or not there is a contractual or non-contractual dispute, or even in the even for dispute related to asset. Vietnamese state is also really open for arbitration. So I think for the arbitration agreement as Article 7 of the model law, we can follow to adopt in the future too. And for example, another point is that at Article 18 of the model law related to the VIART arbitration agreement, I think it's just the technical problem is because the term of from my point of view, the term of Article 18 is quite similar of to the term of Article 18 of Vietnamese law. It's quite similar to the term of Article 34 of the model law regarding the reason causing invalidity of arbitration agreement. This is some point just to share that we can have the possibility to adopt a much more provision to follow model law. And I also understand that it's not necessary to adopt entire model law to become considered as model law countries. And so the question for Vietnam is that we should try to study what is the issue which prevent Vietnamese arbitration or arbitration in Vietnam developed. For example, the problem of the law, or the problem of the philosophy of practitioner. For example, in the chat discussion, I have see a question that the law is not important, but the how to say, the cost is the most important. I share this point too, because if we have we even if we follow the model law, however, then we explain the model law in Vietnamese way. So in this situation, I don't think that we can obtain our objective when we follow or adopt the model law in this situation. And so if we understand that we have the possibility to adopt the model law. Now the question is, what the barriers for Vietnam to overcome when adopting this model law? I think I can share with you at least three points that we should consider. For example, the first one is I think we have to translate the model law in Vietnamese, because we are not like the Singapore country who use English as a national language. Whereas for us, Vietnamese country, we use Vietnamese is the national language. Therefore, when we adopt model law, I think the best way for us is we will translate adopt the philosophy of the model law in Vietnamese law. And the second one is that whether or not we have to distinguish between national and international arbitration. For example, regarding the example of the Singapore, why Singapore can adopt entire model law? Because Singapore has a distinguished system between domestic arbitration system and international arbitration system. So whether or not Vietnam, if we adopt the model law, we have to follow this journey too. And this is, and apart from that, for example, if we distinguish like that, regarding the example of the French arbitration, for example, French law, they also distinguish between international and national arbitration. However, even for international arbitration, the French distinguish between the award issue in France and the award issue in foreign countries. So I also regard the France as an example too, that France is not a model law country. However, France and the UK can be said that become the most choice place of international at international level in arbitration. So, however, France, I believe that has a lot of how to say provision more favorable to arbitration than the model law. However, regarding the domestic law of France, I understand that domestic law, Vietnamese law is regarding the domestic arbitration, Vietnamese law is much more suitable, much more favorable to arbitration than French law. For example, for French law, an award can be subject of an appeal before the national court, whereas according to Vietnamese law, this is impossible. So the problem distinguish between national and international arbitration, I think this is also the issue that Vietnam should take into consideration when adopting the model law. And the last one I would like to share with some discussion in the chat room is that, yes, how we can change the domestic practitioner understanding in arbitration, or the philosophy of Vietnamese practitioner regarding arbitration, because there, for example, there are a lot of a case that I've studied. A lot of party request national court to set aside the award without having a reasonable argument. However, they can react in that way. So this is the problem in Vietnam too. So I think to facilitate Vietnam arbitration in Vietnam, at not only at national but also at international level, we have a lot of work to do. For example, not only we have to train or to educate or to train practitioner in arbitration, but also we have to adopt a lot of how to say positive provision from country or from the model law to improve our arbitration law. So this is something from my part to share with you, and hope to discuss with you in more detail if you have any question. Thank you so much for your attention.
Thank you, Dr. Hoa. I cannot agree with you much more than what you have said. First thing, I really completely agree with you that Vietnamese law has so many common features with unusual modern law. When I read on the 8 issue Ms. Athita Komindr had presented previously, I saw on the key principles of international arbitration, such as competent, severability, party autonomy, independent impartiality, finality, confidentiality, or public policy ground. All that are recorded in the Vietnamese law in one or the other way. Second thing is, you are right, that law is not everything, right? You point out there's so many other things, the same like Dr. Lee's opinion that you need the support from the court system. But more importantly, we need to change the attitude of the user in Vietnam, including the business community and the lawyer, right? That owns the thing we completely agree. I'm not was trained in France, so I have no comment about what you said to compare with Vietnamese law with the French regime. However, when I recall my time to work as a editing member of the Vietnam Lawyer Association drafting committee, there's sometimes raise issues that should we distinguish our arbitration system into two different, international and domestic. But that idea was completely rejected because Vietnam want to follow international best practice in arbitration. And not only in arbitration, in another field of law, we try to follow international standard, right? And please do not misunderstand that what happened at the VIAC or any other arbitration institution in Vietnam is domestic arbitration. No, more than 50% of the case handled under the VIAC rule involving foreign party or international nature, with international nature, like international Singapore or construction or M&A investment, something, and construction, you know very much about that. So I don't think we will reconsider the policy to distinguish our system into different domestic and international regime. However, there are many other things I think you point out very rightly, but I don't think the language is a problem for our legislation, because unusual modern law have 93 states with 126 jurisdictions. And I don't think all of that state and jurisdiction have English as a key language, right? So language is not a problem, but education and training is a problem. That's why we have this webinar. And that's why UNCITRAL love to have Ho Chi Minh City Law University to be in this event, right? Anyway, that is a few comment or observation about your presentation. And now I think we should move to the Q&A session, unless Dr. Lee has a comment. Dr. Lee, do you have any other comment to add with Dr. Hoa presentation?
No, I think you mentioned that the model law is for international commercial arbitrations, but there have been jurisdictions that actually adopted the model law for domestic arbitration as well. But it's really the choice of the states. Some have developed domestic arbitrations more. They have a more improved system so that the default rule in the domestic arbitration is shorter because it's between domestic parties. So that's also a possibility. I think I saw a comment that the model law being adopted in 2006, it's too old. No, actually, it is a minimum standard for people to develop their domestic legislations. So if they are thinking about whether there's going to be an amendment, we say no. We don't think there will be a total overhaul. There is currently discussions to allow for the use of electronic awards, which is to allow arbitrators to sign awards electronically. This is maybe a change to a provision or so, or a paragraph or two, but we don't expect the model law to be amended in the recent years, in the coming years.
Thank you, Dr. Lee. Actually, I just wanted intend to ask you that question, but now it's solved. The next question is, I think that Vietnam law of commercial arbitration is not that much different from fundamental principle of modern law. What else do we need to do with our NCA for Vietnam to be a modern law country? For this question, maybe this question should be raised to the transition representatives that what should Vietnam do more to be recognized by transition and modern law country in the short term? Mr. Lee?
In the short term, I think our review of the 2010 law is that I think it does reflect many of the principles of the model law, but some are missing. And that's why we're looking forward to the reviewed or the amendment law. And as I mentioned, when we do a review of whether it's a model law country or not, we really look at the basic principles of party autonomy, the court interventions, the authority or the tribunal's discretions. And that is what we would like to see in the amendment version, and we're happy to review that once it's ready. I know that it may sometimes take long, but I think what you mentioned is very important. The reform process itself is a training process, and to gain the attention that there is this arbitration framework. Some people may not know that there is even a law, and trying to promote this reform process as an education process is probably what you want to do. And my last comment is you have to address the needs, but who the users are, of course, it's going to be for the Vietnam users. There will be Vietnam businesses that would want to solve their disputes through arbitrations. And if the Vietnam arbitration law is not sufficiently good, the other business partners would say, I don't want the law to be Vietnam law, I want to be another law, which means that the businesses of Vietnam is in a disadvantaged situation. So I think this is something that you need to consider. And really the needs of the users is something for you to consider in the reform process.
Thank you very much. A good point, because 48% of our audience from the business community. So I think that's good for their concern. And we also have 26% of the audience came from the academic institution like the university. So the next question is, may I ask what are the main challenge Vietnam may face in adopting transitional modern law? Maybe Dr. Hoa can give some view on this.
For my part here, I think the most challenge for Vietnamese style to adopt the model law is, as I mentioned earlier, even we adopt model law, however, can Vietnamese practitioner can understand the new Vietnamese law in international way or not. For example, even for regarding the the problem of extension of third part of arbitration to third party, for example, regarding the different country. I understand that there are a lot of practical of international uses to determine the jurisdiction of the arbitral tribunal. Even for the different country like the UK or the France, they have the different judgment in a contradictory way. So in this way, we should, first of all, we should train Vietnamese practitioners so that they can well understand the international practice in arbitration. And if we can do that, I believe that even Vietnamese law has some error or some negative point. However, if first of all the national court and then the practitioner react in the ways favorable to arbitration, I think this would be the good way to develop arbitration. And even now, currently, regarding the Vietnamese situation, Vietnamese practice, I understand that for domestic arbitration, for example, it could be difficult for them to understand a lot of international practice in arbitration. For example, even for the seat of arbitration or for the determine of jurisdiction of the arbitral tribunal. So this is the most important issue when we amend the new law of Vietnam in the future, whether or not we follow the model law or we follow a law of foreign country with really favorable to arbitration.
Okay, thank you, Dr. Hoa. As a question for you, may I ask how can law school in Vietnam help students prepare better for career in arbitration?
Oh, thank you so much for this question. I think first of all, for student, and I can share with you from my experience. I studied arbitration when I was student at bachelor level, and also I defend my PhD thesis in my bachelor thesis in arbitration. And thanks to that, a lot of my time dedicated to alternative dispute resolution. So, and day by day, I have the occasion to work with different dispute related to international or even investment or commercial dispute. So this is the gem for me, and first of all, I think for students who are currently at Vietnam in Vietnam market, the student has a lot of occasion to develop knowledge in arbitration. For example, they can try or work at intern in different big law firm company, and I believe that when they work, they can have opportunity to get involved in different dispute brought to arbitration. And then there are a lot of document or academic writing related to arbitration, not only in national arbitration, but also international arbitration. So I think that students can advance their knowledge a lot thanks to rich document in Vietnam nowadays. And years at our university and also at for foreign forum, there are lots of discussion, a lot of conference related to arbitration. This is the reason why I think currently there are a lot of opportunities for students to follow or to understand arbitration. So this is some experience from my side.
Okay, thank you, Dr. Hoa. There's another question. Could someone please explain the international application of the modern law and the word of the New York Convention? What are the connection? Dr. Lee, can you keep brief about that?
That's a very long question. That requires a very long answer, but the New York Convention is about the recognition and enforcement of foreign arbitral awards. So if an award is rendered in Vietnam and it goes to a court in China, whether the Chinese court will recognize that or enforce that is a different question. Because the Chinese law would not apply. Of course, the Chinese domestic law, if it implements the New York Convention, would apply. So that is the cross-border effect of the New York Convention allows the cross-border trading or trade of arbitral awards. The model law itself is a domestic law where the place of arbitration is in that state. It does not relate to the parties, but if it's an international, or it may actually apply to domestic arbitration as well. And the law provides the default rules or the provisions for the arbitrations in that place of arbitration. I just wanted to also mention, because I'm going back to the users, but in order to expand the arbitration market, there's the need for the users and the businesses to include arbitration clauses in their contracts. This is the first thing, because you need to actually have the users thinking that arbitration is a way to resolve their disputes. They need to include in this contract, they need to indicate that the place of arbitration would be Vietnam, that VIAC would be the administering institutions, and then there's a market that grows. And that is something very important, because we see that there's institutions that have been developed, but they have no cases because there is no contract that results or refers to them. And I think this is something very important to be considered as a bigger legal market.
Thank you, Dr. Lee. I think we have answered many questions on the academic point of view and also on the international point of view. Now we come to the user. There are two questions very practical. The first question is, please point out the anti-shown advantage and disadvantage of the procedure if Vietnam apply it in current situation in Vietnam. And the second question is, can you say a case where not adopting the modern law really made it tough for the party to effectively resolve their dispute in Vietnam? Thank you. So, yeah.
I think the first answer is it's an internationally recognized standard. If you have a deviation from that, you'll need to justify why you're making that deviations. Of course, as I mentioned, you can have an improvement. Model law is a kind of a minimum standard, so you can introduce improvements, but allowing people to know that if this happens in Vietnam, this is the internationally recognized standard, that's probably the advantage of adopting the model law. On the second point, I didn't really get it, but I think they may not have difficulties doing arbitrations under the Vietnamese laws. And I think that is why there is still arbitration in Vietnam, even if it's not a model law country. But I think it's just that there will be not many cases, or there will not be that many disputes being resolved through the Vietnam arbitration law. That's the only downside of it.
Dr. Hoa, do you want to add anything?
I just add regarding the law applicable to the dispute. I just want to draw your attention to the point that if you regarding, for example, Vietnamese law is not favorable to your arbitration procedure, you can the party can choose the procedure law for their dispute, because even for Vietnamese law or foreign law at international level, arbitration of most of countries permit party to choose procedure law for their dispute. So if they consider that Vietnamese law is not favorable to their situation, in this case, they can sign, the party can have an agreement to what is the procedure law to applicable. So I just add information for participants.
Right, thank you, Dr. Hoa. I think as a arbitration counsel for quite a long time, maybe more than 10 years, and now working as a full-time arbitrator. I've been appointed by both VIAC and SIC or IGC to work as a sole arbitrator in the case involving or not involving in Vietnam in the same procedure, expedite procedure. So I can tell you the difficulty and the difference. The first thing is, in Vietnam, what we normally understand the party autonomy just recorded in the arbitration agreement, not in the arbitration process. That's why previously we don't have the kind of the case management conference or procedural order. But luckily, VIC has adopted that best practice in the end of the 2022. And the second thing is, we don't have the similar provision in the uncitral modern law, allowing the tribunal have the full power to conduct the arbitration proceeding as they deem appropriate. That is very important. And we don't not have the similar provision allowing the tribunal to accept the evidence. So many cases under the VIC rule, people try to adopt the evidence rule in the civil procedure code into the arbitration proceeding. So that is not the way the international arbitration proceeds. So we also see many situations when the party change their claim or defend anytime, or even in the hearing, they submit so many new evidence. It's got a lot of trouble for the tribunal, arbitration tribunal, because if the arbitration tribunal rejects that submission, they can be violate due process requirement, and party can apply to the court for setting aside. So there's so many provision we don't have it as uncitral modern law do have, and I'm believe that editorial board of the VNA drafting committee rely that difficulty and challenge, and we try to amend that and try to fix that in a Vietnamese way. But we don't have much time left. There's two questions asking about the training cost at the VIC. So I have to provide this information to complete my job today. Mr. Dung, please provide information on arbitration cost of VIC, or does VIC have training cost for skill in arbitration? Yes, VIAC as a training division of VIC, we have the training cost next March or April, I think. And you can see that at the next week webinar focus on the training and education at the VIC. Judicial Academy also have arbitration class. I think they have about 1 or half day for trainee lawyer to be qualified. But that is short course. Or if you want to learn about arbitration, you can come to Dr. Hoa, right? Or easier than you can use virtual platform of the UNCITRAL. I see many my students come to the UNCITRAL platform and try to learn about that, not only international arbitration, but also international mediation. That is the quickest way and cheapest way to learn arbitration. Thank you. So any more comment from Dr. Lee and Dr. Hoa?
I have just one comment. I know that we've been focusing on the model law, and we did touch upon the New York Convention, but UNCITRAL has its arbitration rules, which is a set of rules for parties to agree upon, which goes further than the model law. And recently, UNCITRAL has also adopted the expedited arbitration rules, which provides for an expedited process of maximum 6 months. So this is also some of a text for people to study, because this is for the parties to agree upon, and it is actually building on the model law as a whole. Just that comment.
Thank you, Dr. Lee, and thank you for reminding me about the anti-zone arbitration rule, because that is a ad hoc arbitration we should mention here, right? Also, ad hoc arbitration case are not very popular in Vietnam, but please be note that more than 10 ISDS cases involving Vietnamese government conducted under anti-zone arbitration rule. So that is very important. And I'm sure that about 50 arbitration institutions in Vietnam can learn a lot from anti-zone arbitration rule when drafting their own rule. Thank you, Dr. Lee. And I think that our time is now over, and we would like to stop here. Unless if the organizer want to say something, we will give the floor to the session 3 of Professor Trần Việt Dũng. Thank you. Thank you, everyone.
Sorry.
Yes, Han, please go ahead.
I'm very sorry, though. So the president of VIAC, who has joined this webinar with us since the beginning, would like to have questions to the speakers. So now VIAC president would like to have a question to all the speakers of this session.
Oh, okay.
I'd like to thank the speakers for a very good presentation. I very highly appreciate the webinar. It occurs in the time of Vietnam very, very decisively carry out the capacity building to develop country as fast as strong as we want. In the course of the restructuring of the institution in the country, arbitration is given by the party and the government very big importance. And we now in process of preparation, as Mr. Dzung mentioned, adopt new law on arbitration, or at least revise, amend very big, with very big provision, very, very big change in current arbitration law. To use the occasion, I would like to ask Mr. Jae Sung Lee and Mrs. Athita Komindr two questions. The first question is, could you identify some differences in influence of the law tradition in binding and implementation of legal regulation on arbitration? I mean, common law, civil law, when the country try to adopt the law on arbitration, is there any difference in influence of civil law tradition? That's my first question. My second question relates to very hot discussion in Vietnam. This is how to follow ancestral modern law, fully follow or follow with some reservation due to the social, economic, and legal features of Vietnam. So I would like to ask you, to what extent the country can trust countries in Asia and in other part of the world follow UNCITRAL modern law. To what extent? If you have any statistic on that, please provide us with these statistics.
Athita, do you want to go first?
Yes, but so can everyone hear me? I think just very quickly, the statistics of the Asia Pacific jurisdictions that have adopted the model law are currently at around 30 jurisdictions in the Asia Pacific. So that would be about half of the jurisdictions that RCAP services. So yes. But again, the status of the model law adoption on the UNCITRAL website, I think is also and Jay could speak more to this, but I think it's also a little static because it's not able to actually fully reflect the jurisdictions and the states that are actually considering a model law or that have also adopted certain principles without maybe having adopted 100%. Because in updating that status, I think UNCITRAL takes a more conservative approach. There might also be smaller jurisdictions that have adopted but have not yet brought that information to us. UNCITRAL Secretariat is quite small, so we might not be able to monitor everything all the time. So I think that would be my preliminary answer. Thank you.
On your first question about civil and common law, I think the law itself, the model law, has been prepared to accommodate both civil and common law traditions. But it is how the arbitrary tribunals conduct their proceedings may actually differ depending on where the arbitrator is coming from, a civil law tradition or a common law traditions, where they're used to document productions, where they're used to more of an controversial or kind of a more of an adjudicatory process. So I think that's where the difference lies. I know that some states have been saying that the model law is too common law based, but I don't think we see that in the arbitration field. We feel that the model law is able to be accommodated in both in civil law and common law. And I think VIAC probably may wish to introduce some civil law traditions in the procedures themselves, but not in the model law. Whether to follow fully or partially, I think we've already discussed. It's up to you to decide. Fully is better, but of course, if you need to adapt to your needs, we are happy to do that. And to what extent, that's what we do. We assess whether it is to the extent that it actually builds on the basic principles of the model law. And if it goes over that extent, it is not a model law country. But we're happy to assist in that process. Thank you.
Thank you for your answer. And my last, not question, but wish or request. In the future, we will organize some scientific conferences and seminars on adoption of new arbitration law. I'd like to invite you to participate if you are ready. It will be very good luck for us.
Thank you. We'll be happy to participate because we have a MOFA colleague in the room. We have a MOU with the Vietnamese government as well to cooperate on all these reform elements, and we'll be happy to participate. Thank you.
Okay.
Thank you so much for this discussion. Now we come to the end of the section 2 and move to the section 3 of the webinar on overview of UNCITRAL work on the Investor States Dispute Settlement Mechanism ISDS reform.
Hello.
So So I'd like to invite Associate Professor Jae Sung, the Vice Rector of the Ho Chi Minh City University of Law, will moderate this session. Professor?
Yeah, hello.
Thank you.
All right, thank you for introductions and welcome all to the session 3, where we'll dive into the UNCITRAL important work on the reforming the investor-state dispute settlement, the ISDS systems. And nowadays, as we all know, the ISDS plays a key role in the resolving the investment disputes, and this reform are especially relevant to investment-driven economies like Vietnam, as they navigate the balance between the investor protection and public policy goals. And for today's panel, we are honored to have two distinguished presenters. Mr. Jae Sung Lee, the Senior Legal Officer of the International Trade and Law Division of the United Nations Office of Legal Affairs. I think he has shared his views in the previous sessions, and Ms. Athita, the Deputy Director General of the Department of International Law of Vietnam Ministry of Justice. And we really would like to have to receive the informations and sharing assessment of your in our panel. So please, the floor is for you to welcome to Mr. Lee. Yeah, could you please start the presentations?
Great. I've been speaking a little bit too much, so you might be bored. But as you mentioned, I mean, first, I think we have to understand what ISDS is. I mean, if a foreign investor wants to invest in Vietnam, they may not be so comfortable of going to a Vietnam court where their claims can be addressed. And that is why VITs usually include a provision whereby investors are able to raise a claim through arbitrations. And we've touched upon why arbitration is there. So that's the basic mechanisms. And there have been a number of investment treaties or even free trade agreements, which includes these investment dispute resolution clauses, where a foreign investor is able to raise a claim through an international tribunal under ICSID, under PCA, or under the UNCITRAL arbitration rules as an ad hoc arbitrations. And that's where we're coming from. There has been an increasing number of ISDS cases or investor claims, which has actually raised the concerns about the ISDS itself. There were first about some concerns or about the arbitrators themselves. Are they really fit? Are their conduct or their ethics really abided by? Second was, we have all different decisions because it's an ad hoc or institutional arbitrations, but the tribunals are established also as an ad hoc basis, and therefore tribunals have rendered inconsistent decisions, which is another issue of concerns. There's also criticism that their decisions are not correct. Also, as mentioned, there's been a big concern about the time and cost that is required to address these kind of investor-based disputes, especially for developing countries with very limited resources. Because they have to handle all these claims, they have to devote their entire team for these purposes. And I think we have one person here who's actually devoting a lot of time to here, so we'll hear from her. But this has actually been a concern for many of the developing countries. So that is why UNCITRAL was asked to consider reforms on how to make it better, how to improve the ISDS system. This began in 2017. I can go a little bit back to the history, but since we're running out of time, just to shortly, when we were adopting or amending the UNCITRAL arbitration rules, the need to ensure transparency in investor-state dispute resolution was emphasized, and that is why UNCITRAL came up with the rules on transparency for treaty-based investor-state arbitration. That was the basis of UNCITRAL's step into the ISDS world, and they thought that it was possible to undertake reforms of ISDS. And because all of these ISDS provisions are contained in the bilateral investment treaties, there was a need to amend all of these in order to have the reforms being implemented. And that is why UNCITRAL was tasked in 2017 to consider what the problems are, whether it's going to be desirable to undertake reforms, and then develop concrete recommendations on how to reform ISDS. And here I'll share my slide. So after a long debate, as you see on the screen, UNCITRAL was able to come up with a code of conduct for arbitrators, which addresses the conduct and the ethical behavior of the arbitrators in their conduct of the arbitrations. It has some new provisions, for example, limiting double hatting. It has a very extensive procedure on disclosures that is required of the arbitrators. And this was passed 2 years ago in the 2022, along with a code of conduct for judges for a potential investment court to be established at a later stage. During that year in 2023, another aspect that was highlighted is that arbitration is a very costly process. There should be a way for parties, investors, and states alike to use mediations to save costs and to reach an amicable resolution of the disputes. And that is why UNCITRAL adopted the model provisions on investment mediation as well as guidelines, allowing them to look at all of the different aspects that arise in mediations and what to consider and how to make use of it. In relation to that, the UNCITRAL has prepared a draft toolkit on dispute prevention and mitigation. So the best is actually not to get to an arbitration, but also to not get to a dispute. And this is why UNCITRAL is preparing a toolkit on dispute prevention and mitigation. This year, UNCITRAL adopted a statute, a multilateral advisory center on ISDS, or international investment dispute resolutions, whereas the advisory center is supposed to allow developing countries, but all member states, to share experiences about ISDS, how they have handled their teams, how they've handled cases. But also an important aspect is to provide representation services for developing countries and least developing countries. There are instances where countries have signed BITs with ISDS clauses without knowing the impact of such clauses, and therefore sometimes they're faced with claims by investors, and they have no team to address those claims. And that is why, in those cases, the advisory center, when it is up and running, would be able to provide such support and try to give them. It's not supposed to be a full law firm, but it will be coordinating closely with the local teams to assist and defend their cases in a tribunal case. What is currently being discussed is what you see on the bottom of the screen. There is the reform of a permanent investment court. So rather than relying on arbitrations, having a separate court to address all of these cases is seen as a possible solutions to address all of the problems that I had mentioned about the arbitrators, because they will be permanent judges, about the process, because they will be all there will be consistency among the decisions because it's a permanent court, as well as the fact that if it's a permanent court, they will be able to control the time and cost that is generated from the proceedings. That is the permanent investment court that you see in the middle. There is also a proposal to discuss the appellate mechanism, because currently arbitral awards are rendered, and in order to address the inconsistency or the incorrectness of those awards, the development of an appellate mechanism, whether it's a standing appellate mechanism or whether it's an ad hoc mechanism, is also being considered by Working Group 3. Another aspect is the procedural rules reform and cross-cutting issues. This is, if you know, ISDS is mostly handled by ICSID, with about 70 to 80% of the cases being handled by ICSID, which is the International Center for Settlement of Disputes, Investment Disputes, located in Washington. But they have gone through a reform process to improve their rules to address the concerns about cost and durations and a number of other aspects. So UNCITRAL wishes to do the same so that it covers the rest of the cases or those cases that are ad hoc cases which may not be reported on ICSID. And that is why we are undertaking procedural rules reform. And what we refer to as cross-cutting issues are the mandate that UNCITRAL Working Group 3 is with regard to procedural reforms, but there are certain procedural solutions that may be able to address some substantive considerations or substantive problems. I think the three that have been identified are counterclaims, also on the right to regulate of states, on how much difference the tribunal should give to this right to regulate, as well as the calculation of damages and the compensations that are awarded by the tribunals. So all of these are being considered in UNCITRAL's Working Group 3. It is a government-led process because UNCITRAL is a intergovernmental negotiations body where the intergovernmental bodies come together and negotiate. It is a consensus-built process. We're trying to ensure that as many states can participate, and we have a number of developing countries also from Africa and Latin America participating, and we would like to see more participation from Asian states to participate in this process so that the reform can be actually productive and result in very concrete results. Now, what you see in the middle is the multilateral instrument on ISDS reforms, because this is a tool, a treaty, that would allow for the amendment of all of the BITs through a simple procedure. I say simple, but it is a very complicated text that is being prepared by the working group, so that states that wish to adopt any of the reforms that you see on the screen can become a party to the multilateral instrument and choose the reform options that they want to choose. And if the other party to that treaty wishes to adopt the same reforms, they have a match of minds, and that reform is then incorporated into their investment treaties. I think that's a nutshell. I only took about 10 minutes because we're running a little bit late on time, but I think I'm happy to answer any questions. It's a very short overview of what UNCITRAL's Working Group 3 is doing. UNCITRAL's Working Group 3 webpage, if you just Google UNCITRAL Working Group 3, you'll see an extensive page of all the reforms and all of the documents that are there. There are quite a number of documents, so you may need to look at all of the documents, but on the right side, they are organized by reform elements, and you'll be able to find all of the reference material there. So with that, I pass it back to the moderator. Thank you.
Thank you, Mr. Lee. I think the presentation is wonderful, and I would like now to invite Ms. Nang, who will share the views relating to the Vietnam and the ISDS. Please, Ms. Nang.
Thank you, Professor Dzung, and actually I have to thank Lee for your very comprehensive presentation. It's been within only in 10 minutes, but you can brief the overall pictures of what we have done for almost 10 years. So thank you very much for that. I was asked to talk about the implications to Vietnam regarding the issues of ISDS reforms. So probably I will follow what the structures of this presentation, talking about the concerns first. But this is the concerns from Vietnam, especially Vietnamese governments regarding the ISDS cases. And you all know that we also have to face some of the ISDS cases, and all over the world, there are more than 1,000 cases already in place, and many cases has been awarded with excessive or very big amount of damages, up to like billion, and I have counts from UNCTAD that up to now there are 14 case awards that award the damages more than $1 billion US. So that's a big thing. So why talking about that? Because that's one of our most concerns, has been expressed within the working group 3. That's the way for calculations of damages. And actually, Vietnam has very actively involving in this discussion. Besides that, we also have shared the concerns of many of other states, like the concerns regarding the arbitrators themselves, or regarding the consistencies of the awards, as well as other issues like the procedural issues like the third-party funding, security for costs. And actually, there is one more thing that has not been extensively expressed in the working group, but probably Lee will see from our comment recently. These 3 issues of rules of evidence taking, where Vietnam has faced the situations where the claimants collected the evidence illegally. That means, for example, that's the confidential documents, but they still can obtain that in the illegal way. And in the other case, we have faced issues where the claimants fabricated the evidences and even making the fraud documents. So that is the very big issues, I think, and it is violate the public policies in international law. So therefore, that's another concerns from Vietnam. So what we expect from these reforms? So as a developing countries where Vietnam share with other developing countries that we have faced a lot of problems with ISDS, we understand that protection of investors is the way to encourage the foreign investors in Vietnam. However, ISDS systems sometimes go beyond the protections of investors and sometimes creates a lot of burden to the government, the host governments. So therefore, we pay a lot of attention and we actively participate in the reforms under the Working Group 3. And our focus would be on the first is ensuring the independence and impartiality of arbitrators. And that's why the Code of Conduct was one of our priorities. And we also have actively participated in the finalization of the Code of Conduct, especially the issues of double heading. And we hope that the code will be widely used in the future and it applies in practice. So the second issue is we should have the clear rules on third-party funding and security for costs. Vietnam also expressed its views in the working group about these issues, and what we would like to emphasize is the links between the third-party funding and the security for costs. That means in case that the parties receive the third-party fundings, then the funders should also commit to cover the costs if the other parties were awarded with the cost recovery. The next issues, and the one that I have already mentioned, is the rules of taking evidence. So to take into account the issues of illegal taking as well as the fraud and fabricated documents evidence. And another issue is about the establishment of the advisory center. So this center will address the issues of costs and time durations of the ISDS procedures, especially costs. And actually for Vietnam, we would like to look for the assistance from the center in both types of services. The first one is strengthening the capacities of our team of the government officials on dealing with the ISDS cases, and also in not only dealing with ISDS cases, but also on prevention and also understanding the standards, and also but the second type of services we also would like to seek for the support from the center would be the assistance on the specific cases, especially in the early stage of the cases, like the appointing the arbitrators, general assessment of the case, as well as case management and looking for counsel, for example. So that is also our priorities. Regarding the issues that we are discussing, like the court or the appellate mechanisms, we still participate in the discussion, but still we have not making any decisions on that yet. But probably that also the issue that we should take more time to consider, since it will address the issues of consistencies and the correctness of the ISDS awards. So that is the implications for Vietnam, and also priorities for Vietnam. I was also asked to talk about the influences of the reforms in practice. And I have noticed that many of the issues discussed under the Working Group 3 have been taken into account by the tribunals. For example, the issues of granting of security for costs, or asking for more disclosures on third-party fundings, or even the issues of double heading. So we can see that many arbitrators now become the full arbitrators to avoid the issues of double headings. And also for damages, we can see that tribunals now are more cautious on making the decisions on damages. And like the statistic from Exit recently, they have a case where the damages is zero, even though the government was found breach of the treaties, but the damages is zero. So that is all my it's a presentation. Thank you very much.
Thank you very much, Ms. Van Anh and Mr. Lee. And I think that during your presentation, Ms. Van Anh, you have mentioned about the advisory board. And I think that is very interesting institution that have been discussed at the UNCITRAL Working Group 3. And I also would like to start to ask the sharing about from the Mr. Lee about the scope of work and the expectation from the working group regarding this advisory board and advisory body, and also Ms. Van Anh, to which extent you feel that this advisory body could help a country like Vietnam in the ISDS disputes. Yes.
Yes, I'll do that, but I just wanted to comment on the first Laity's comments. I think what we see in the working group is that there are very different interests. Vietnam has its interest. Other countries have different interests, and they put different emphasis on different reforms. For example, the EU is very keen on the institutional reform of the standing court. There are other states that are more keen on the other reforms. So this is something that I just wanted to highlight. And I think I agree with her. I think the discussions in UNCITRAL, I'm not just complimenting of UNCITRAL's work, but the discussions at UNCITRAL has already affected tribunals' practice, because now they're aware of all these concerns by the states, and this has also changed the attitude of the tribunals. On the advisory center, we still have a few years to go. The statute was established, but of course, where it is to be located, who is going to be the members, what is going to be the budget, how many people will be working, but that's all to be decided, and that's why we expect a little bit more development in about a year or 2 years' time. It is supposed to be assisting developing countries and least developing countries in handling their disputes. So when they are faced with a claim, or before they're faced with a claim, or if the investors tries to approach them about a claim, the advisory center is able to help not only in arbitration, but also in mediations. I know that some people have mentioned mediations in the chat. So in the different dispute resolution processes. But another factor is that what UNCITRAL's Working Group 3 has been able to do is that we've been able to bring in together all of those who are handling ISDS cases, the governments, and there has been no forum for that. I know UNCTAD has been functioning as a forum for IIA disputes, which is the International Investment Agreements, but these are who negotiate the agreements. There has not been a proper forum where people who handle the disputes can come together and discuss all of the reforms or share their experiences. And UNCITRAL's Working Group 3 has been able to conduct that work. But UNCITRAL's Working Group 3 cannot continue forever, and it is foreseen that the Advisory Center will take over that role and then function as a forum where people can share experiences, and also like the mediation guidelines can be trained, capacity will be built. There will be also possibilities for government officials to work at the advisory center so that they gain experience. And of course, so I said, it's a work in progress. On the screen, I think we call it the operationalizations. We had the first operationalization meeting in Thailand. We'll have a second meeting in Armenia, Yerevan, in May next year. But then the commission will continue to do that. UNCITRAL has not done institutional reforms. UNCITRAL has not established a new institution yet, but it's a new endeavor for UNCITRAL and its working group. So we look forward to that result. Thank you.
Yeah, thank you. I think it's interesting. Your point of view regarding the development, and I would like to ask, how can a country like Vietnam adapt their legal system to better align with the UNCITRAL model law and the evolving needs for international investment disputes? Mr. Lee, can you share some like important highlights?
Well, unlike the model law, which has been adopted by a number of states and it is considered the international standards, all of the reform elements that UNCITRAL is developing is for states to choose. It is not an international standards. As Lai mentioned, if you want to have a rule on third-party funding and security for cost and rules and evidence, the idea is that states are able to pick and choose from those reforms. It is not going to be an international standard where everybody has to adopt the same standards. And it's really up to the states to choose to address their needs. And I think this should be bear in mind for discussions.
Right, thank you. Okay, I think for Vietnam now, I think when we're discussing about the ISDS, we tend to talk generally from the perspective of the states. But from my observation now, Vietnamese business also investing overseas a lot. And with the current ISDS system developed by Vietnam under the networks of the investment agreements. So I would like Ms. Viet Anh to share how those regime could help the Vietnamese companies in their investment activities internationally.
Yeah, thank you, Professor Dzung. Yes, actually, our businesses and enterprises are now investing overseas more and more. And actually, the investment agreements, including the bilateral investment agreements and also multilateral agreements or free trade agreements, that has the investment protection commitments also play a very important role in not only protecting the foreign investor coming to Vietnam, but also protecting the Vietnamese investors coming overseas. So this is one of the very important tools for protection of their investments. So for those, actually, we have some of the cases already that the Vietnamese investors invest overseas and where their investment has been damaged by some severe activities of the or conducts of or measures of the governments of the host states. But since there's no investment agreements, and those they couldn't protect themselves from such activities. So therefore, in my opinions, when seeking the opportunities for investing overseas, among the businesses opportunities, commercial interest, and all kind of that, to see whether the host countries has any instruments or investment agreements with Vietnam should also be taken into account, because in that way it will be protected by the agreements. It's not only about the ISDS systems, it's also about the substantive provisions of the agreements where the host state has to provide the protection to foreign investment in that state. So therefore, I think that the enterprises should take into account that issues together with other issues when making the decision to invest overseas. Thank you.
Thank you. I see this one question quite interesting from the audience. The question is, what is the chance that the commercial dispute will later lead to investor-state disputes? And can you share your insights? So, Mr. Lee and Ms. Van Anh, could you please share your views on the question?
I think it's a very simple question in the sense that whether it is protected under a treaty or not would actually allow whether it goes to the ISDS case or not, or treaty-based case or not. Of course, investors as a commercial party also has the possibility to go to our commercial arbitration. So it's whether they fall under the protections of the investment treaties that probably would determine discussions. I see that there's a little bit of discussions about substantive protections for foreign investors being overly protected over domestic investors. I think this is of also a substantive nature, substantive protection standards for the states to decide. If you don't provide them, they might not invest in your country. So this is also something for the states to consider. And I know that, I mean, everybody calls that mediation is perfect, but under the context of ISDS, you may also need to, I'll just pose two questions. Who is the party that is going to be mediating on behalf of the state is one question. And if they do mediate, and then somehow they agree on an amount, who is going to be responsible for that decision is the second question. This is a very difficult question, and although I do recognize the benefit of mediations, it poses a number of challenges, especially in ISDS cases.
Regarding the questions, when the commercial disputes becoming the investor-state disputes, actually, I have been asked this question several times already. So the issue is that, like Mr. Lee already explained, if the major of the state violate the treaties, that will can become the investor states. But there's another thing. For example, that when a commercial arbitration or the commercial dispute can become an investor dispute, that is when for example, in the case of government contract. So like the contract between the government and the foreign investors on specific projects or specific issue, specific projects. And then there is under the investment agreement between the host countries and the countries of the investors, there is the umbrella clause. In that case, then the commercial disputes can the investor can choose either to bring the disputes under the treaties under the umbrella clause or under the contracts. Is the choice of the investors. And regarding the issues of the mediation of ISDS disputes, investor-state disputes, I totally agree with Mr. Lee that even though there's a lot of advantages of mediations and conciliation, but for the government, the two questions that Mr. Lee has raised is very hard questions to be answered by the government. Thank you.
Yeah, I think now the time is almost to close. So I think we can come back to the general like the Q&A session for the whole 3 sessions. So if the audience still have some questions to the all panelists for the presenter from the beginning until the panel number 3, we can ask the presenters to share and their views.
I think maybe all the questions are exhausted. Maybe all the participants are exhausted seeing all the very interactive discussions and engagement on the chat and in the Q&A. I just wanted to point out that we've put several links to the UNCITRAL documents, including those of Working Group 3 that Jay had mentioned, in the chat box for those who are interested in learning more. Also links to the internship program and the online learning modules. So thank you.
And just to add, the comments from Vietnam on the procedural rules, including evidence, security for cost, and third-party funding, is also available on the Working Group 3 website.
So
probably, I think there's several questions on the ISDS issues in the boxes. Probably I should address some of them. So there's one question. So I read some of the studies that developing countries in Vietnam suffering several disadvantages if being sued by investors from rich countries. Could you please enlighten me on those and how Vietnam deals with those? Yes. We do face challenges when dealing with disputes with the investor from rich countries, because especially those very big corporations, international corporations, where they have the very big legal team, very high-ranking lawyers to defend and to develop their claims. And actually, Vietnam also a country, we also developing countries with limited budgets and resources. And however, in those cases, we still have to use external counsels and good counsels to defend ourselves, to defend the governments, because if we don't pay much attention in defending ourselves, the result will be severe. Like we will receive the very big awards, so big compensation. So that is not what we expected. So therefore, we for all the claims and all the cases, we deal with them in very carefully way, and we normally use external counsels, the international law firms, to represent the government with the direction from our departments, from my team, to make sure that the case goes in the right direction. And another one I would like to address also is, if losing in ISDS arbitration is so common for developing countries just to be safe, we should settle. Yes, the issue of settle, sometimes maybe that we can settle with the reasonable amount, but not always. Because in many cases, the award actually, the damages award is actually much lower than what was requested by the claimants. So therefore, it's not easy to make the decisions on the amounts for settle unless it's very clear on the violation on the breaches and also very clear on the damages.
I just want to share a bit about what Ms. Nang has mentioned. I think there are some MNCs, I mean, or foreign investor who use the strategy of taking the states to the international tribunal to give pressure on the states, and sometimes it depends on the investment agreements and provisions on regarding how the state protect the foreign investors. And I think recently, I think one of the good example of that Vietnam met in negotiation with the European Union. They have some regulations to prevent the cases where the investor just abuse the right and take many cases to against the states. So the state can consolidate the cases, and they can sue to take the states to the international tribunal only once. They can they cannot take the state several times in different tribunals. So I think that is I think also some development in the investment agreement negotiation of Vietnam, and I think Vietnam also made some important agreement with some partners in the CPTPP to avoid the disputes. And Ms. Evelyn may share more in detail for the audience about that. And I think that the experience of the Vietnamese governments and the Vietnamese government officer, legal officer in the case, it now play more and more important role. Yeah, just thank you for just want to share. Yeah.
Yes, actually, the EVIPA and also the CPTPPs are some of the advanced agreements that have includes many of the advanced substantive rules on the protection as well as the ISDS issues. And actually, for example, in the case of CPTPPs, is limit the scope of the protection standards to like the fair and equitable treatments only limit to the denial of justice or the due process issues, and to exclude the issues of legitimate expectation, for example. And also CPTPPs and EVIP provide very strict rules and procedures for the investors to go through before they can sue the government. And also there's some kinds of regulations where to avoid the issues of parallel proceedings or like multiple cases against the state in the same time. So that is some kinds of advanced agreements that taken into account all the concerns of the state during recent year on the ISDS, and they have produced some of the very good provisions on that agreements. So those are two agreements that I myself also very use very commonly when giving lectures or presentation to different training courses on the developments of the investment treaties. Thank you.
If I may just add, I think these kind of agreements that Ms. Vanon mentioned is actually the basis of our reforms as well in the UNCITRAL'S department. We're trying to improve the system rather than trying to throw it away. I know that there have been some states that are not happy with ISDS, actually abandoning ISDS in their treaties as a whole, or moving to SSDS, or actually not allowing for investors. But that also has an impact on whether they can attract investment in their home country. So it is they have a bigger picture of what all these reforms relate to.
So I think we're right at the closing time. I think we're exactly at the closing time. So should we pass the floor back to the event moderator? Thank you.
Thank you.
Thank you so much. And
I think
Professor Dzung, would you like to say a few words to close the session, or we should leave it to the organizer, VIAC, Ms. Hằng?
Right. Okay. So yeah, thank Ms. Anh. All right. So okay, I think that the the workshop, online workshop, was really fruitful. We have received a very interesting and very deep analysis and access of the existing situations on the ancestral model law, the applications. We also have been discussing about the various issues relating to the investor-state disputes from the angle of the UNCITRAL and also from the angle of Vietnam. And I hope that the audience have received very fruitful sessions in today. And on that note, I would like to express our thanks to the to all the four presenters of our honorable guest presenters who have very who are very open and very thoughtful to share information with us. And I would like to say also thank you for all the audience who are attending the conference from beginning until the end today. And thank Mr. Dzung who for your valuable time moderating the sessions. And on this, I like to declare that we have accomplished our missions, and we have a very successful workshops. And I hope that it will be the start for the future workshops and conference that we can gather together to discuss and share our knowledge and expertise about the arbitrations field, which is very important area now in the global economic corporations. Thank you very much for all of you.
Thank you and goodbye.
Goodbye.
Thank you. Bye.
thank you so much and goodbye.
And a Happy New Year to everybody.
Thank you.
Happy New Year.
Bye-bye.
Happy
Merry
New Year.
Christmas.
Merry Christmas and Happy New Year
Bye.
season.
Thank you. Bye.
Bye-bye.
Mm.